Despite these Supreme Court decisions, I must regularly explain to my clients that while they can choose to join any worship, house of worship, any affinity group, or fraternal organization that they want, federal law prevents them from choosing the agent that exclusively represents them in their workplace. And in half the states without right-to-work protections, they must pay union dues or be fired.
And our final witness is Mr. Glenn Taubman, who is a staff attorney with the National Right to Work Legal Defense Foundation, which is located in Springfield, Virginia. Welcome, Mr. Taubman. And finally, Mr. Taubman, you're recognized for 5 minutes.
Thank you for the opportunity to appear today. I have been practicing labor and constitutional law for over 42 years at the National Right to Work Legal Defense Foundation in Springfield, Virginia. My clients are individual employees who wish to stand apart from the workplace labor union they did not choose and do not want. For 42 years, I have helped litigate the Foundation's groundbreaking Supreme Court cases like Communications Workers versus Beck and Janus versus AFSCME. These decisions recognized individual employees' constitutional and statutory rights to partially limit their association with labor unions they wanted no part of, but were nevertheless forced to join or fund. Despite these Supreme Court decisions, I must regularly explain to my clients that while they can choose to join any worship, house of worship, any affinity group, or fraternal organization that they want, federal law prevents them from choosing the agent that exclusively represents them in their workplace. And in half the states without right-to-work protections, they must pay union dues or be fired. But since October 7th, those once routine explanations of basic labor law have become dark, sobering, and often heartbreaking conversations about the reality of union anti-Semitism and legalized compulsion in the workplace today. Now my phone is ringing off the hook with calls from unionized Jewish and Israeli graduate students at this nation's elite educational universities, MIT, Columbia, University of Chicago, to name a few, asking me how they can disassociate from the union that is partnering with and often leading groups that organize protests to shut down the campus, destroy property, chant genocidal anti-Semitic slogans, and menace them on campus. Many of these employees are forced to pay dues that go directly to subsidize the union's celebration and support of Hamas's massacres. In case any of you need reminding, Hamas is a medieval death cult on the U.S. government's terror watch lists, not unlike ISIS and Al-Qaeda. Wearing masks at the workplace while chanting "Death to Zionists from the river to the sea" is not benign or legitimate union bargaining activity. My phone is also ringing off the hook from medical residents and interns at some of the nation's finest teaching hospitals, asking the same question as their union is busy poisoning their workplace with hateful and exclusionary anti-Jewish and anti-Israel propaganda. My phone is ringing off the hook from teachers and legal aid lawyers, all of whom wonder how the union they used to support and even champion had suddenly turned away from advocacy for better benefits and toward radical advocacy against Israel's just and moral defensive war, a war that is occurring thousands of miles away from their workplace. Federal labor law has long allowed employees to be trapped by exclusive bargaining agents they never voted for and do not want. But today, Jewish employees find themselves forced under the thumb of exclusive bargaining agents who are loud and ardent supporters of the Hamas death cult. At the National Right to Work, we are redoubling our efforts to help such employees forcibly saddled with anti-Semitic unions. We have filed Beck charges because unions falsely tell employees that they must join and must pay dues, even when the money is spent to support radical campus protesters, and we have filed charges of religious and ethnic discrimination with the EEOC because unions refuse employees' requests for religious accommodations. But despite our best efforts, Title VII and Beck are not nearly strong enough protections. As long as unions can force workers to pay anything to get or keep a job, employees will be denied their full freedom of association, speech, and conscience. The Janus decision was a small step for employee freedom in the public sector. Now is the time for this Congress to pass the National Right to Work Act in the private sector to end the problem of coercive forced unionism and the particular problem of compelling Jewish and other religious employees to fund unions whose views and activities are hateful, threatening, and deeply divisive. What could be more American than that? Thank you, and I look forward to answering your questions.